Good afternoon. Is it afternoon yet? No, still good. It's still morning. Good morning.
I was just making correct. He's the acting premier.
Oh,
He's the acting premier.
I overlooked that.
Sworn by the judge.
My humble apologies. Welcome, acting premier. Yeah, I was assured that he is connected. Mr. I'm sorry, just help me. How do you pronounce your name? I hate it when people mangle my name. I don't want to do that with yours.
It's not a problem. It's Matshitse.
Matshitse.
Yes.
All right. Good afternoon. Oh, good morning. Still a few minutes to noon.
Good morning, DCJ.
How are you?
Fine, and you see DCJ.
I'm fine, thanks. Well, you appeared before this commission not so long ago. It was in October 2022. Yeah, so correct. You are not a stranger here. We know you, and I don't expect that there'll be many questions for you. But you never know. Don't hold me to that. We remember you for your many academic qualifications. You have a deep juris, an LLB, 2 Masters of Law, and a string of diplomas.
That's correct, DCG.
And you are a regional magistrate of many years.
From 2015, that's correct.
From 2015.
Yes. But acting before in 2010.
Mm-hmm. And you have acted as a judge for many years now.
Yes,
since
2016. That's correct.
And since October 2022, have you had an acting stint in the High Court?
Yes, I did have an access in 2023.
For how long?
For 6 weeks.
Mm-hmm. So what does that make the total sum of your acting period in the High Court?
I think it makes 58 weeks.
All right. And we know that you have written judgments, some which have got you in trouble because there were complaints from the law bodies and the commissioners that you did not take particular care in the quality of your judgments before you deliver. You do not proofread. In some, that was the charge.
That's correct, DCG.
Mm-hmm. During your recent stint, did you have a chance to write any judgments?
Yes, that's correct, DCJ. I think 2 that have appended, Molefe and the other one.
Mm-hmm. Well, it seems that your latest efforts have not earned you pardon, because there is still a complaint from the GCB, for example, that your work is sloppy, for lack of a better description.
That's correct.
Would you like to address?
That's correct. Let me just start by saying that that judgment also, it's the one that the same or the period that the foreshare, the one that made me put me in trouble the previous time, and it was appended on the same period. But I would like to say again, I really apologize for that, and it's regrettable in that regard. And I have, as I've indicated, improved or tried to improve very much. During that period that I was doing, I appended the said judgment. I did not teach myself, I was not yet taught very well about computers, in the sense that nowadays I know now how to structure, in the sense that, like, for example, you start the numbering, for argument's sake, like in this case that I was doing them manually instead of allowing the computer to follow up if you enter or did, let's say, on a computer setup as such. So I really, really apologize in that regard. I won't articulate that since the last time I've improved in that regard. Thank you, DCJ.
Yeah, I just, let me first ask, what is the status with your second LLM? Have you acquired it?
No, not yet.
Not yet.
I'm now on the proposal. I'm busy with the chapter on the first chapter in that regard. I've been asked to finalize it this year.
Yeah. No, I just wanted to express I fail to understand how someone is so scholarly would be accused of producing work that had basic mistakes such as grammatical errors, typos, and all that. It just doesn't tally with what I perceive you to be.
I do understand DCJ. It's sometimes I'll say what caused that in most probably it was because of pressures. And I think when I did the judgment on that one, it was the time that I went back to the office and with regional court where I'm stationed, you have a lot of work that one has to do. It's not an excuse if I put it that way, but however, it was during the time that one has to. You find that you've got three trials, postponements, and many matters. And then when you get the chance to do that, when you read your judgment, when I'm doing it after I was at home, you find that I take it for granted that I'm at this paragraph and this, and then at the end, when I'm supposed to submit it, when I read it as if, or automatically it's on my mind. But really, in that regard, I apologize. That's why I'm saying this judgment that has been said or that I've made a mistake. It's during the time that Foche was also involved, because the same GCB previously, they were happy with my judgment and everything in that regard. But I do, as I say, DCJ, I apologize. And it's an error that I take it that I won't do it again, or it's not going to happen.
Well, there is another error I want to point out to you in your questionnaire, your application form now, the very first page, paginated page 4 of the bundle.
Page 4.
Page 4, yeah, where you state your personal details.
Personal details.
Yeah, section 1 of the JSC questionnaire.
And page 4, it's the previous.
The heading is section 1, personal. That's
the first page.
Yes.
Okay.
Section 3 requires some personal details.
Oh, this one. Thank you. Sorry. Oh, page 4. Yes, I found it. Thank
Yes.
you.
You have not stated your date of birth, your place of birth, importantly, and your citizenship. And if you had not appeared before this commission before, I would not know if you're a South African, which is actually critical for the validity of your application. Why did you not fill in those details?
I think when I read that, I think it should have been a mistake. Say certain personal matters you can leave out. I think when I completed that, I deleted the citizenship, everything in that paragraph. I was not aware of that I've left it, the citizenship in that regard.
All right. So where did you act in 2023?
I beg your pardon, sir.
Where did you act as a judge in 2023? Your last acting stint?
I was
Where
in
was it?
I was acting in Pretoria.
In Pretoria.
Yes, DCJ.
So you still have not acted in the Northwest Division to which you seek appointment?
I've not acted, but I've raised my hand to the JP previously, the last time I was here in 2022, that I'm available to can act. And he did reply to say that he will come, or the secretary did reply that the JP will come back to you regarding that. I've raised my hand in that regard. Yes, I have not yet acted.
Okay, other than for that 6-week period you were acting in the Pretoria High Court, what else have you done with yourself since October 2022 that would enhance your standing as a candidate before us today?
Except not assisting in the aspirant regional magistrate who were appointed last year. I was doing lectures in that regard, and also assisting or whenever I'm being called. Like last week, I was called by the church at AME to come and lecture, or not even lecture, give a discussion on GBV and domestic violence. So I've been trying to involve myself in the community as such. And besides that, I've been in my court in Boysens or Johannesburg.
All right, thank you so much, Mr. Matshitse. Do you have questions for the candidate, JP Hendricks?
Yes, thank you, DCJ. Good afternoon, Mr. Matshitse.
No, it's good afternoon, JP.
How are you?
Fine, and are you, JP?
Good, thank you. Can I also follow up on the questions by the DCJ
Okay.
with regard to this application form? Do you have children? Do you have children?
Children?
Yes,
Yes.
because that in 4.2, that is also not indicated.
It's not indicated.
Yeah, on the form.
I did not indicate this, as I indicated to DCJ, that the questionnaire, particularly when it comes to, they say, personal matters, one can not state them. But yes, I do have children, but they are adults.
Very well.
DCJ, sorry to intervene like this. Sorry, JP. Could that information be provided to us, please? The place of birth and the date of birth now, so we have an idea as well.
Well, he is here. Will you please tell us when you were born and where you were born, and state your citizenship, please?
Okay. I was born on the 23rd of August, 1961 in Johannesburg, but I grew up in Northwest at Rustenburg, Phokeng, or Mosanton, as they call it. I attended school, primary school in that area. I also attended school in Phokeng. And
No, you don't need to go into that detail. So you are a South African citizen.
Thank you.
Are you a South African citizen?
I beg your pardon?
Are you a South African citizen?
Am I a South
African citizen?
I'm an African, South African citizen.
Okay.
That's
Thank
correct.
you. Okay, carry on, JP.
Thank you very much, DCJ. From your CV, it's clear that you will be turning 63 this year, isn't it? 63 years of age?
Yes, currently
your
I'm
next
60.
year.
I'll be turning 63 on the 23rd of August.
Yeah, and you are regional court magistrate.
Yes, I'm
Currently.
a magistrate.
Yeah, and regional court magistrates retire at the age of 65. Isn't it?
Yes, you can sit
Still
until you are
apply.
65, but I think you can ask for extension until you are 70.
Yes. I was still busy with the application form. Can you perhaps go to paragraph, I can just find a place now. paragraph 6 on page 11. Let me start there. Under the heading court experience.
Page 11.
Yes, page 11
Paragraph.
of the application form, paragraph 6.1.
Is it on the forms?
On the form, yes.
Because page 11, I don't know whether I'm on the correct one. It's
It's paginated page 14.
page
at the bottom.
14 on the page.
At the bottom.
Okay. There's paragraph 4.
Yeah, paragraph 6.
6. Do you appear in court? Yes, sir.
You indicate frequently.
Frequently.
And then the question is, please give the details. And then you indicated, I do not appear in court as a practitioner. I preside in court as a presiding officer on a daily basis. Can you see that?
That's correct.
Yeah. But I'm interested to know, what is your experience like when it comes to criminal law, administrative law, constitutional law, labor law, or other civil law, as asked in 6.2?
Okay. That-
Perhaps you can give it percentages.
Okay. Currently in the regional court, that is, if that I'm appearing daily, it's criminal, it's let's say 60% to 70% of criminal work in the regional court. And administrative law might be not much, 1%, and constitutional law, nothing at the in court, and labor not also at all. But the other one is just civil work that we do. Regional court does civil work in that, divorces, actions, and all that.
Yeah. But during your acting stints in the High Court, what percentage of work did you do as far as, for example, civil work is concerned?
In the High Court.
Yeah, in the High Court, vis-a-vis criminal law.
Okay. If you look at my CV, I've done 26 weeks of criminal law, and I will say 32 weeks from the 58, 32 weeks of civil, but spread over, not specifically for one thing, like civil trials, civil appeals, and also opposed motion, and interlocutory applications. So if I group them together, it's as such 32 weeks. But mostly 26 weeks, it was criminal trials and also on the same criminal appeals in that regard.
And did you also in the High Court do more criminal work than civil work? Did you do unopposed motions?
I've done unopposed motion for about 2 weeks.
How many?
How many matters?
Letters, yes.
I wouldn't say, because let's say in Pretoria, one gets about 10 matters in that week. Let's say I would say you get about 5 to 10 matters for that particular week that you'll be sitting on a motion, unopposed, and also in that regard, Johannesburg in. So I can't give you, some will fall through, some will proceed in that regard. That's where some of the judgments that I've made are coming from the opposed motion in that regard.
Yeah. You know, the Northwest, 80 to 90% of the work is civil work in the Northwest.
That's
Unopposed motions, we now have a cap at 100, because at one stage there was 177 unopposed matters on the roll for a Thursday. The roll closes on Tuesday and then you get the files. I want to know, will you be able to cope with approximately 100 unopposed matters, having a day and a half to read?
If I get you correct, that 100 opposed,
Unopposed.
unopposed. No, unopposed, that one I can, because before the JP changed the directives in Johannesburg, one will get about 150 or 100, more than 100 for that, let's say, like you say, on Tuesday. Definitely, you'll sit on Tuesday, you'll get the 100 files. And also, when you came out of court, you'll get another 100 or 150 to that for Thursday. But nowadays, what happened is that with the new directive, one gets daily unopposed motions. So you get about, at the maximum, it's about 40 to 45, or in that regard. So on a daily basis, yes, I will be able to cope unopposed. And also, because with interlocutory applications also, you get 35, 50, 45 per day. So in that regard, I would definitely be able to can cope with the load, case load. And also with my experience and also working under pressure from the regional court, and as a former, I've worked in asset forfeiture I know it's unopposed, but because of motion, then I will say definitely as an attorney, I will be able to cope in that.
Yeah. You indicated in your application form that there were 2 cases,
Yes.
9.4, that leave to appeal was granted, but you don't know what is the outcome, whether it's finalized or not. Why didn't you inquire about?
I did. I even sent after getting this note, and from GCB, the query that in that regard, I tried to find out from the registrar of in the High Court in Johannesburg, and he said he does not have anything. He cannot tell me what happened to them at this stage. I'm trying to follow up. I even asked my former secretary in that court to follow up. So far, they have not yet come back to me.
Yes. At the time when you submitted this application form, you were acting as a regional magistrate. You are a regional magistrate, isn't it?
I'm a regional
Yes.
magistrate.
Did you have any part that matters?
In the regional?
Yes, when you submitted this application form.
I
And
do
if so,
have-
how many?
I have part heads, as I indicated, that we have a lot of work. But so far, my part heads are about less than 7 so far.
Less than?
7.
Less than 7.
Yeah.
Thank you. I just want to point out one other thing to you, over and above, and it coincide, let me put it this way, it coincide with a grammar problem,
With
with a grammar, the complaint
Yes.
or the concern raised about
That
the
there was
grammar and the
raised,
spelling.
yes.
Yeah. In the judgment of Sarel Petrus du Plessis versus the state, do you have that judgment?
that I've appended.
Yes.
Also.
Yes. The first one.
Is it? Oh, the
Sarel Petrus du Plessis.
yeah, the one of Mpumalanga.
Yes.
That's
When you go to paragraphs 2, 5, and so on,
paragraph.
2, 5, 9, there's reference to a record. See transcript, page 2 to 5, for example. Paragraph 2, Paragraph 2 of the judgment.
2 to 5.
Paragraph 2. Let's deal with paragraph 2 first.
Yeah, on offenses, the topics of
Yes.
Yes, sir.
Now, at the bottom there, you refer to see transcript pages 2 to 5. The same appears on paragraph 5. See pages 241 to 251 and 163 to 188 on application. Now, the reader of this judgment won't know because it won't be before the reader. Paragraph 9, see page 250 to 251 of the transcript. I don't know whether you attach the transcript to your judgment because the reader won't know.
It was not attached, JP. I do understand that I should have perhaps quoted the paragraphs in that regard.
Yes. Can I just run something else by you, and this is about the proofreading of the judgments before you append the signature and before you give it out. I see the judgment of Isaac Piet Mofokeng. The case number is 3163 of 2018. Do you see that?
Isaac Mofokeng Piet.
Yes. Isaac Piet Mofokeng, Visitor Road Accident Fund. Do you have that judgment?
Yeah, RAF, yes.
And
JP.
the next judgment is an X Corporation Limited and Lawrence Maruas. Now, what struck me when I went through the judgments is it is the same case number, 3163 of 2018. Was this the same case or is it different cases?
It should be different cases. 3163 and 20, it might be the date of the last date, the year that should have amended in that, because they all come from Mpumalanga. I think that's where also I made the mistake in that.
Okay. Can I ask another question in the judgment about Isaac Piet Mofokeng?
Isaac Mofokeng.
Yeah, if you go to paragraph 3. It seems to me from paragraph 3 that the parties inform the court that no witnesses will be called and that the matter may be adjudicated on the joint minutes or affidavits to that effect. But I don't see that the court ordered in terms of Rule 38, Sub-Rule 2, that the matter can be decided on affidavits. Was such an application made?
I did not mention it on the judgment.
Yes. Thank you, TCJ.
Thank you very much, JP. Acting Premier, do you have questions for the candidate?
Oh, good morning, DCJ. I think I only have one question. It's related to cases of medical negligence.
All right, go ahead.
The only thing that I would want to hear from Mr. Matshitse, have you ever presided over such cases? And if yes, what are the lessons that you have learned from those cases and what advice can you provide?
I've never presided in respect of medical negligences in these cases, except reading about them.
Also, you have never presided over such cases?
No, I've never.
Yeah, because the judge president can attest to the matter that they have such cases. And I think it's a lot of cases, and such cases are costing this government a lot of money. These are the matters that you might want to look at. But the second question, which will be my last question, there's something funny that is happening in the Northwest Province. The majority of councillors here in the Northwest, on matters of intergovernmental relations, they prefer to take those issues to court. And the court, more often than not, must be seized with these matters almost on a daily basis. Do you have an advice as to what is it that we can do, or are there other mechanisms that can be applied to address issues of intergovernmental relations instead of us taking those issues to court?
Can I request that ask the Premier to repeat the last part? I did not get it quite clearly.
DCJ?
Is that
DCJ?
Commissioner? Yes. Is it Commissioner Malema?
Yes.
Yes. How can you help
The
you,
acting
Commissioner?
Premier of Northwest is really violating this meeting. He's putting his video with a political party emblem at the back. And he's doing this deliberate.
My goodness.
He's got a
I had
political
not even
party
looked
emblem
at
at the
the
back.
screen.
Which means he has brought an ANC flag in a meeting of the JSC.
Okay, it's
This
sorted
is
out,
perfect.
Commissioner.
Don't try
Malema.
that next time. You must respect this prince. It's not a branch of the ANC.
Can I request the Premier to...
My apologies, DCJ. I think we are correcting that. There is no need to fight over it, but
No,
we are correcting
we have a beautiful view of Lion's Head and a cloud overhead over Table Mountain and the sea. So we're happy with that.
Let's ask the minister if that view is better than the ANC flag.
Just repeat your second question, Acting Premier, please.
No, I was simply saying, are there mechanisms which Mr. Matshitse think we can consider to cap the use of the High Court to deal with matters of such nature, matters of intergovernmental relations?
Medical, there is something that I don't quite get it clearly, Premier, in that perhaps I'll ask DCJ if we have the question clearly, if you can just repeat it for me, perhaps because there is a lot of echo that I cannot hear properly in that regard.
Please repeat the question again, Acting Premier.
No, I can repeat that. Thanks very much, DCJ. I'm no longer on medical negligence. I think Mr. Matshitse did answer the question that he has never presided over such cases. My second case was related to councillors who are taking each other to court on a daily basis on matters of intergovernmental relations. So my question was, are there any mechanisms that you think we must think about to keep such use of High Court to deal with issues of intergovernmental relations? Thank you very much. I hope I was clear now, DCJ.
Okay, of councillors, if correctly, that they always take each other to court in that regard, shortly in that, if I understand it correctly. One can, like I said, I grew up in Northwest, and I won't say glued up in regard to traditional authorities, but however, I will say that one have to teach or try to go to the councillors and show them that it's not worth it to educate them what is supposed to happen and what is the correct thing that is supposed to happen in terms of the Traditional Authorities Act and what is required in that regard. I don't know whether I did answer the Premier.
There's
DCJ,
answer from you.
DCJ, I think let's leave it there. I'm okay.
Sorry?
He says
No, I was
let's leave
saying
it
it's
at
fine,
that.
DCJ. That was my last question. You can leave it there.
All right. I'll ask your last question then.
No, I'm saying that was my last question.
Oh.
We can leave it. We can leave it there. Yes.
Okay. Okay. Thank you, Acting Premier. Are there any questions for the candidates? Commissioner Narumachai?
Thank you very much, DCJ. Matshitse.
Good afternoon,
Ayuwa.
Prof. or Councillor.
I have a question for you. Since we don't have a lot of judgments, perhaps, that came after your last interview, and we cannot really assess them to the extent to which we want to. But I just want to ask you a more substantive question with respect to the art of judging generally. Let's say you are presiding over a matter where there is a new set of attorneys who looked at a matter and they believe that it's a motion proceedings, and they believe that the notice of motion does not capture that which the client actually desires, and then they want to do something about it. One, in order for them to capture what they think their client needs, what should be done, what application can be brought with respect to that notice of motion. And if indeed there is an application that can be brought, what is the test that must be met in order for the client to be successful in changing the notice of motion, as it were?
They want to change the notice of motion.
Yes.
Okay, in terms of rule, they can bring the application in terms of Rule 28 to amend the notice of motion in that respect.
What is the test? Because it's not an application that you push and it's given. What will then be the test that the court will have to consider to see whether it is competent to grant such an order?
They number one, they will have to file the notice of intention to oppose. I mean, the notice of intention to amend. And when they filed, as long as it won't change.
Let me try to assist you. Now, let's say in their application, there's a founding affidavit. In the affidavit, what test do they need to satisfy you with for you to be able to grant, to make an order, whether to grant or to dismiss the application? What is the actual test that will guide you in whether or not the application is competent?
The test is that why they have to explain clearly why they did not state it during the normal affidavit originally when they filed, and the court will not just accept it in that they have to be sensing clearly, or they have to be more go too deeper in that respect.
I'm afraid not, but let me not take it further. Let me leave it there, DCJ.
Thank you, Commissioner Narumachai. Commissioner Steinberg?
Thank you, DCJ. Good afternoon.
Good afternoon,
Mr. Matshitse.
Chancellor.
I'm looking at your judgment in the application for leave to appeal in the Dance Sport South Africa matter, which starts on 108 of your questionnaire, of your application.
I've got it, Commissioner.
Would you go to page 110?
Yes, Commissioner.
So you cite the test for leave to appeal that is set out in Section 17 of the Superior Courts Act. And at paragraph 6, you say, the test laid down in Section 17 of the Act is now a subjective one and no longer an objective test. Would you explain what you mean and why that's the case?
After reading several cases in that regard, that they made a ruling that it's after the amendment of Section 17, objectively it was looking at what will other person or
Recording
the
in
reasonable
progress.
person do, but more now it's more straight that you have to make sure, or it has to be sure that there is a prospect of success in this. It's no longer a broad one, if I explain it that way. It's not a broad, but it's narrow interpretation in that regard, in the test, in order to prove to the court that you have the prospect of success.
So why is that now subjective instead of objective?
As I indicated, it's from the interpretation of other cases that, like the one that I've quoted of Van Heerden, that the test now is more of a subjective than objective test.
Well, I think what that case points out is that the word should have a reasonable prospect of success is replaced with would have a reasonable prospect of success, as you point out. But the test remains objective, it's just stricter. Subjective would mean that the judge doesn't take objective test of reasonability into account, but is subjective about the subject. It doesn't speak to the difference between should and would. So it's unclear to me why you describe it as a subjective test.
I won't take it any further, but that's why I'm saying in that after reading several cases and following that one, that's why I went to that. I said it's more of a subjective than the objective one.
What do you understand the difference between an objective and a subjective test in law?
Subjective, it's more on a personal, or on a personal one. Objective, when you look at holistically other, I will use the word reasonable man, what will have happened in that regard. But subjective, it's more concerned with the person or yourself, a narrow interpretation in that regard.
Okay, thank you.
Thank you, Commissioner.
Commissioner Rudolph?
Oh, it's my turn. Thank you very much, DCJ. Good day, Magistrate.
Good day, Commissioner.
Yes. One of the major problems that this and concern that this commission had with your candidature in 2022 was about the grammatical errors that were picked up. Everybody picked these grammatical errors, legal bodies and so on. Now, if I put it to you now that, and I'm raising this question because during the deliberation, I'll argue that your application and how you have crafted this application, including your judgments, are worse than in 2022. How will you respond to that? Because in this particular instance, you missed out all the necessary information that is required. This question, the first time when I came here, I thought perhaps that I didn't understand why all this information must be subjected to the candidates. But later I came to understand the rationale behind that. But now, with all this information that is missing, if I put it to you now that I'm going to argue that you are worse than the way you were in 2022, what will be your response to that? I want to afford you this opportunity to really share with the commission, that concern that I have.
Thank you, Commissioner. I won't say that it's worse, but I will say that I've put back the same, when I say same judgment or of the which were in 2022, and I won't say that it hasn't changed that very much. I agree with you, but not being worse, but it's still this sort of on the same length as such. But I do understand your point in that, more particularly after what was raised by JP and DCJ with regard to the citizenship and the date of birth and others, that in that regard, I left it out when I did that. But I do understand what the commissioner is saying.
No, it's okay. The last one, DCJ, I asked almost all the candidates who came here for the Northwest, and I'll ask you the same question. Northwest is 65% rural. Most of the disputes that are adjudicated by the High Court relates to the traditional authorities, councils, and so on, in terms of the Traditional Leadership and Governance Framework Act of 2003. Have you ever interacted with that legislation? And if yes, in what ways?
Have I ever interacted with?
Interacted or resolved a matter that pertains to the Traditional Leadership and Governance Framework Act of 2003?
I wouldn't say after 2003 I was here in Gauteng, but previously when I was in Northwest and when I was at the land court, not land court, the Department of Land Affairs, I interacted with the chiefs and the traditional authorities. So in that regard, whenever we were at their places, I was able to can advise and be able to assist them in that. But since when the act came into operation, I've not been in Northwest, but at home, I do assist wherever they say the chiefs or the headmen in my village will ask questions or ask guidance in that, but not formally in a formal way.
Thank you, DCJ.
Commissioner Mumeng?
Thank you, DCJ. Good day, Mr. Matshitse.
Good afternoon, Commissioner.
Thank you. I just have one question, which emanates from one Mr. Muntsiwa's letter in support of your candidature.
Yes, sir.
Yeah, there's a referral to, in his letter of support, that there was a need to appoint a Motswana male judge in the Northwest Division. The concern that I have, this letter of support, it's an undertone around tribal chauvinism and ethnicity, which run against the spirit of building a rainbow nation. Now the question to you is, what is your reaction to this? Because to me it is a spoiler. I don't think such undertones in today's program of building a new nation, there is a space for such.
Commissioner, in the first place, I should say I did not even know Mr. Ramatlale. It just came, I was surprised when I saw it as such when it came in. But if I think he raised I don't know whether one will say the tone of his letters when we are trying to build a multiracial or in that regard. I wouldn't answer for him, but yes, it has to, one can interpret it as saying he wanted to bring to the attention of the commissioners or to the JSC that we have Botswana and the area is a Botswana area, and one will understand the rules and the custom of that place. So yes, on the same breath is that it's sort of he is pushing for separation and he's not pushing for other nations that can come forward in that. But I cannot take it any further that for him, he can answer that. But yes, I might agree with you in that. But I'm just saying that he wanted to bring forward that perhaps demographics should be taken into consideration, the race in that area. And like in the say for argument's sake only in the constitution that the appointment of a person try to be suitable in that, but does not exclude a competent person if he's found to can be appointed, even if he's not Botswana.
Let me leave it there, DCJ. Thank you.
Thank you, Commissioner.
Commissioner Muimanga, do you have any questions for the candidates, commissioners on the virtual platform?
No, thank you.
Commissioner Malem? Commissioner Shabangundawe? Commissioner Pillay?
I said no question from my side.
All right. I'm sorry, I struggle with this. Matshitse.
Matshitse, yes,
Pardon me.
DCJ.
We have reached the end of your interview, sir. Do you have any questions for us?
No, Commissioner, thank you.
Well,
No,
thank you for
DCJ,
making yourself
sorry.
available again. You're excused.